everyone. Welcome to today's program, The Nuts and Bolts of First-Party Property Insurance. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Daniel Veroff. Daniel is an attorney at Merlin Law Group. He has devoted his entire legal career to insurance law and has recovered hundreds of millions of dollars for policyholders. He represents property owners in large loss insurance claim disputes, underinsurance matters, and agents, brokers, and underwriter negligence, and serves on the board of directors for United Policyholders, the world's leading nonprofit insurance policyholder advocacy organization. We're so excited to have him with us today and hear everything he has to share, so I'm going to turn it over to him.
Thank you, Ala. Thanks for everyone for coming today. So, this is our presentation, the nuts and bolts of first-party property insurance. Going to go over the legal nuts and bolts for the most part, and then some sort of technical nuts and bolts to get you familiar with how these claims and cases work. Next slide, please. All right, well, there's my contact information if for whatever reason you would like to get in touch with me. I'm licensed in California, and that's where I primarily practice, and I'm going to be only going over California law today. I'm also licensed in Oregon and Washington, and the Merlin Law Group has offices all over the country and licenses in most states. We also have a great daily blog, and it's a great website you can navigate to look for information on first-party claims. So save that web address there as a resource for learning more information about these cases. Next slide, please. So what is property insurance? Well, this quote from one of our leading cases on insurance bad faith, Garvey versus State Farm, is right here. Property insurance, it's an agreement, it's a contract. The insurer agrees to indemnify the insured if insured property suffers a covered loss. Well, okay, so we know it's a contract, right? And the insured is the one being indemnified. But unlike a third party claim, it's the insured's property that they own, and they have to suffer a loss that's covered under the property. Next slide. All right, and here's another nice little quote from Garvey. All right, so coverage is going to turn on references to causation, right? So we are going to have the subject matter of the insurance, the property at issue, and then, well, is something covered? If yes, is it excluded or limited? Well, those typically will turn on issues of causation. And next slide, please. So, starting to dig in a little bit, here are some of the basic principles, the really basic nuts and bolts. So, in California, we have what we call a standard form fire insurance policy. It was originally came out of New York, and so it can be called the New York standard form. It's codified here in 2070 and 2071 of the insurance code. 2070 tells you that every fire policy in California has to be on the standard form. And 2070 is often cited to invalidate provisions of policies actually issued that provide less coverage than the standard form. If you look at 2071, which has the standard form, it is not how your insurance policy looks. But the idea is that the policies actually written and issued have to provide substantially the same coverage. So it includes minimum coverage requirements, right? One of those is all loss by fire. There have been disputes over smoke damage, for example, and there have been successful challenges to those limitations because all loss by fire has to be covered. There are a few other things in there like lightning and wind, but otherwise, in terms of causes of coverage, it's pretty limited what actually has to be covered. Water, for example, water damage counts for a huge portion of claims. It doesn't have to be covered. It's sold almost by every single policy out there. Sometimes it's limited, but it's a prime example of something that's beyond the standard form. Another critical part of the standard form is for claim-related documents. A lot of states don't have this right, but when you have an insurance claim, you are entitled to receive copies of documents related to the measurement of the loss and the valuation of the loss. Doesn't mean you get everything. You don't get the claims journal, you don't get proprietary information, but you get estimates, you get reports, anything that relates to the valuation of the loss and coverage of the loss, or at least generally everything. There are also some neat legal changes coming to this that's going to allow you to get every version of an estimate or of a document. For example, insurance companies hire vendors to write estimates for them, and maybe they cut that estimate down or they tell the vendor things to change about it. So there's a new law change that's hopefully coming to 2071, which lets us get every version of those reports, not just the final version. Proof of loss is a big concept in the insurance world. It's a pretty relaxed concept in California, but all policies can and will have a provision that if the insurance company asks, you have to provide very detailed information about the loss and the damages within 60 days of the request. In California, it's pretty loose to comply with a proof of loss. Technically, all you need to do is exhibit the damaged property for the insurer to investigate. But still, it is best practice if an insurance company demands a proof of loss that you comply with it. And that is similar to an issue we're going to get later, which is the burden, right? The burdens of proof on the insured versus the insurer. The insured absolutely has burdens of proof. The insured does not have to do everything, but we'll get into that. Another really key cornerstone here is the appraisal provision, which you're going to find in 2071. And for example, if you read a State Farm policy that's sold today, it has an appraisal provision that is inconsistent with 2071. So always check to make sure that the provisions like that are consistent. Well, what is appraisal? Appraisal is an alternative dispute resolution form for property insurance policies, and it relates only to valuation and scope of loss. An appraisal is an interesting process. Either party can invoke it in an average claim. In a state of emergency claim like a wildfire, it's got to be mutual. But if it is invoked or mutually accepted in the right claims, then each party picks a representative called an appraiser. They have to be independent, unbiased, and qualified to do their job, and they can be challenged if they're not. But each side picks one, and the goal of the appraisers is to determine if they can come to an agreement on, again, the scope of the loss and the value of the loss. And if they can't, then they pick an umpire, and the umpire serves as the tiebreaker. There aren't a lot of procedural guidelines on how appraisals go, and so you'll find they go a lot of different ways, depending on what certain parties insist on. Sometimes they have full-blown hearings with witnesses and testimony. Other times it's all done virtual visits and, a property inspection. So there's a lot of freedom there. Appraisal awards are legally binding. They're very difficult to overturn if you go down that road. An interesting thing about appraisal is that it doesn't address coverage issues. So, for example, you have a loss, and the insurance company says, well, part or all of that loss is caused by wear and tear, and that's not covered. It's excluded. And you say, well, here are my experts and my evidence that it's caused by, fire or water, whatever the covered loss is. Well, you have a dispute there. The appraisal process is not going to resolve that. That's what the court process is for. But you can still proceed with appraisal over valuation and scope of work issues if you have a coverage dispute. And the appraisal award is typically just here's the dollar amount, and here's, the scope of the work that goes with it. And then how that gets divvied up later, if you have a coverage dispute, in court, that'll be down the road. So that's the appraisal process. There's a lot more detail to it, and it's constantly changing. Parties are trying to apply California arbitration law and have been decently successful in that. So appraisal is a complex beast, and that is something that is going to be in every one of these policies originates from that standard form. Loss valuation, how you measure a loss, meaning how you determine the dollars to pay someone for the damage. We're going to get into that a little later. And so I'll save more comment there. Suit limitations, that's a statute of limitations. And statutes of limitations for specific causes of action are trumped by the suit limitation clause in the insurance policy. It is a minimum 1 year based on what's in the standard form. And that's the average of what you'll see. You're often going to see policies with more, and that's great. 2 years, it can be common. If you have a state of emergency claim, there's a statute that modifies that to a minimum of 2 years. And something you're not going to see in 2071 or any policy form or any insurer letter. Well, you're not going to see it in most insurer letters is tolling of the suit limitations. So let's say it's 1 year, and it says right in there in 2071, it's 1 year from the date of loss. But we have case law. Prudential LMI is the big decision for tolling of statutes of limitations. And that says it starts running when the loss occurs, but stops when the claim is reported. And while the claim is being adjusted, it's tolled, it's paused. So that 1 year clock isn't running once you report that claim, it's on hold. And when is it going to start running again? It's going to start running again when you get a denial. It's going to start running again when the carrier makes a final position on valuation, when there's no denial. And one very important practice pointer that gets missed a lot is the whole claim is subject to a myriad of suit limitations. For example, we're going to get into it in a second, the different types of property that's covered under a policy. You might have different types of property that are damaged in one loss, but let's say you get a denial on one type and you continue adjusting the claim on the other. Well, there's a suit limitations clock that's running from the one that was denied, even though the other property implicated in the loss is still being adjusted. The whole claim isn't subject to a suit limitation for that first denial, but if you wait past that year, that issue that was denied is going to be gone, right? Because suit limitations means statute of limitations. So pay careful attention to tolling. And again, you're not going to see it spelled out in policies, and you're rarely going to see insurance companies mention it, even though they're going to cite their suit limitations clause in their denial letters. So very important to look at. You might think a claim is expired, but it's not because of tolling. Okay, let's move on to the next slide. So let's talk about the anatomy of an insurance policy, right? It's a contract, and it's going to have, like any good contract, a lot of different provisions, hopefully covering every possible scenario that comes up. Interesting thing, of course, a contract is typically something that, comes into play right away after it's executed. An insurance policy is a promise. It's a contract where the insurance company, they promise to do something if a contingent event occurs. You're always going to be paying. That's not contingent if you want the policy enforced. But because it is a little bit different than a standard contract, we have special rules of interpretation and special liability rules, which we'll get to in a little bit. But the anatomy. So declarations, right? The declarations page is The most important part because it is unique to the particular policy, whereas the rest of it is most likely going to be standard forms that are assembled. And the declarations are going to list everything you really need to know front and back. For example, even if they don't have all of the forms attached to the declarations you have, there should be a list of the forms attached to it. And what else is a declaration is going to have? You're going to have the essentials, who's the insurance company, right? Sometimes it's listed as the underwriting company or the issuing company. But keep in mind, you might have, a claim denial with Farmers logo on it, and the actual company is Fire Insurance Exchange, right? So look at the declarations to see who the actual insuring entity is, and they're your actual defendant if you file suit. The declarations are all going to show the different types of covered property. We're typically going to be seeing, for example, in a homeowner's policy, dwelling coverage, other structures coverage, which covers anything from pools to concrete, some fences often. Personal property is going to be a third category of coverage, which, is take a house, turn it upside down, shake it, anything that falls out is personal property. Other covered property, well, you'll have additional coverages, which they include covered property. But interesting, the declarations pages don't always show the additional coverages. So that's one thing actually where you'll need to look in the details of the form. So, for example, coverage for trees and shrubs and plants and lawns, things like that, or debris removal, right? So there could be extras in categories, as well as extra dollar amounts associated to them in the body, the forms that are attached. But so in the declarations, right, in addition to showing the type of covered property, it'll show the associated limit. A policy limit in California and in many states, it doesn't mean, for example, the house burns down to the ground, you get the limit paid, right? There's still a method of valuing the loss, and theoretically, it should be at least the amount of the limit if it burns down, but that's not how our policies work. So you see limits referenced, that's going to be a maximum that gets paid, but it's not going to be an automatic that gets paid for something like a total loss. The declarations pages are also going to name any additional insureds. Oftentimes, a mortgage holder is an additional insured, sometimes family members or a trust or an LLC. But you'll always see those additional interests listed there, as you should. You'll see premium amounts. Like I said, you'll see other forms that are listed. So if you have the whole policy, you can check that declarations page to see if you really have everything produced. So covered property, I just hit it pretty much, right? I mean, we're talking about buildings here, and we're talking about things that come with buildings, personal property, right? When you get into commercial coverages, they get a little more complex. For example, a winery, right? A winery, they own property, they own machinery, they have grapes on the vine, they have grapes that are picked and in process, they have, bottles, they have bottled wine. So depending on the type of commercial property, you can have much more expansive types. And then you're going to have these sections called additional coverages or extensions of coverage. And these are going to be things again like debris removal, like I mentioned. So, debris isn't covered property, but if you have a loss, you have costs of removing debris. That's an additional coverage. A common one you'll also see is ordinance and law. We call it code upgrades, colloquially. So the insurance policy should pay to rebuild what you lost, but sometimes you can't build it the same way because of code changes. And so that increased cost of construction because of code change, that ordinance and law, right? Those are all similar names for it. That's an additional coverage. Plenty of others, not going to go over them all. So covered causes of loss. You either are going to have a named peril policy or an all risk policy, and I'll address that on the next slide, but you want to pay attention what type you are, and for each type of property. For example, in many homeowners policies, the dwelling will be covered on an all risk basis, but the personal property will be covered on a named risk basis. And again, I have a couple slides on that in a second, so I'll get in detail there. You'll have an excluded causes of loss section of the policy. And exclusions are very important. When you have an all risk policy, right, everything's covered except those excluded. And exclusions are usually pretty extensive, pretty detailed. You'll have standard exclusions on every policy, like, faulty workmanship is one example. That'll be excluded in almost every policy. But you'll also have exceptions to exclusions, such as, oh, we don't cover the cost to make good the faulty workmanship, but if a loss flowed from that, then we cover it, right? Like if they didn't do the roof right, they won't pay to make the roof good, but they'll pay for the water that came through the improper roof in the rainstorm. Um, you have your loss settlement provisions, which are going to set out in the policy how you value a loss. Again, right, a lot of these are required by the standard form, but it's going to get into a lot more detail. Things like coinsurance, which is a penalty for underinsuring yourself, are found in there. Not just what is paid, but what is paid first and what you have to do to qualify for different types of valuation to be made on your claim. All that's outlined in the loss settlement. You'll have your conditions, which sets forth things like the suit limitations period, the proof of loss. It'll have a duty to cooperate in there, which is submitting documents, exhibiting property, basically helping the insurance company with anything it reasonably needs. Conditions are very important. Got to comply with them. A breach of a condition could be a reason not to pay the claim. Some conditions, when they're breached, the insurance company has to prove they were prejudiced by the breach. Others, it's automatic. For example, if there's a condition to file your claim within a certain time after a loss, but you don't get it in on time, it's a prejudice issue. Did the late notice prejudice the insurer's ability to investigate the claim? But if it's an examination under oath, which is the condition that requires you to sit for a deposition-like exam with an attorney under oath on the record, if you don't comply with that, then it's not a prejudice requirement. So those conditions are very important, and some of them lead to automatic denials, others have that prejudice requirement. And then endorsements. So endorsements exist because most insurance companies either take a standardized form from somewhere else, or they write their own based on, one of the most popular ones. And that's the core of the policy. And then they modify it. There can be endorsements for California that they add because it's a policy they sell in other states. There can be endorsements for extra coverages you buy or extra exclusions that are added to your policy. Endorsements govern over the terms of the standard form, which is the big chunk of the policy. Okay, that's the essential policy anatomy. Remember, one other thing, all the first party coverages are typically going to be in section 1 of the policy. Section 2 is the liability, the third party, which we're not going to get to today. Let's go on to the next slide. All right, so I promised that we would get to the difference between a named risk and an all risk policy. Here's Garvey again, a great case for us. The insurer agrees to indemnify the insured in the event that the property suffers a covered loss. So a covered loss means it has to be covered, but in a named risk policy, it's specifically enumerated. There will be a list that says we only covered losses caused by the following. And when that happens, the burden of proof to show that it's covered, that one of those covered losses occurred, is on the policyholder. And we'll get to those burdens a little more in a second. Let's go to the next slide. All right, and here's all risk from Vonderleef. All risk policies, well, the scope includes everything unless it's excluded. So all risk says anything under the sun as long as it's not on our list of exclusions. And when you have an all risk policy, the burden is no longer on the policyholder to prove that there was a covered cause of loss. It's only a burden to show that the property experienced damage. From there, the insurance company bears the burden of proving an exclusion applies. Let's go on to the next slide. So let's talk about scope of coverage or excuse me, scope of coverage provisions and exclusions. So again, when I say coverage provision, we're talking about either that all risk or that named risk section, right? It says what we cover. And then you go on to exclusions, right? What was within the coverage grant, but we take it away for some reason. So because insurance policies are special, right? And why are they special? Again, they're in special because they're standard forms. They're not negotiable. They are a promise to pay when the policyholder is down and out. They are sold by very powerful companies and owned by the average Joe. They are, um, uh, well, that's probably good enough reasons for now because I'm just going off the top of my head. But there are a lot of reasons why we don't want to treat these exactly like standard contracts. So, when we're talking about a coverage clause, we're interpreting it as broadly as possible. So let's say you have a named peril policy and it says, we cover vandalism, right? And you have a loss. And let's say a homeless person snuck in and started a fire in the kitchen to keep warm and it burned the house down. Is that vandalism? Well, vandalism might mean, causing property damage with intent, and possibly with malice, right? Well, maybe we're going to find that that specific loss, that homeless person or unhoused person, whatever you want to say these days, I'm trying to keep up. Um, but for the fire they started to keep warm, does that count as vandalism? Well, they set it on purpose. They should know fire inside of a building, outside of a fireplace, right? No good, very dangerous. Um, but they're trying to stay warm, right? So let's say it's covered. Let's argue it's covered, right? Because we're interpreting these broadly. But exclusions, those get interpreted narrowly to preserve coverage. So let's take the same situation, but it's a different policy. We've got an all risk policy with exclusions. So they cover everything unless it's excluded. Now let's say vandalism is an exclusion under this policy. So now we're asking, okay, well, the unhoused person, they broke in, they lit the fire to stay warm, but they should have known it was probably gonna, burn the building down. Well, are we gonna say it's vandalism here? Yeah, we should. We should argue it's vandalism here. Because if it's vandalism, or I'm sorry, no, we should argue it's not vandalism. And get that straight. We should argue it's not vandalism here. Why? Because if you're interpreting that exclusion narrowly to preserve coverage, then you don't want it to be vandalism because vandalism is the exclusion. And so if you're saying, well, they started it to stay warm, but they knew it was probably going to burn down the building, let's interpret that exclusion narrowly and focus on the intent. Now there's coverage for vandalism, even though it's an exclusion. So again, that's an example of a scenario where maybe we're going to look at part of a policy or the same situation differently if it was a coverage clause versus an exclusionary clause. All right, let's go on to the next slide, please. So we are going to talk about one of the most important slides here on insurance claims. Now, this provision is applicable to more than just first party, but it is absolutely a very important regulation to know for first party claims. So this falls within the what we call the Fair Claims Settlement Practices Act. These are regulations from the insurance commissioner, and they tell you, right, how should a claim be handled properly and promptly. So, some important provisions, right? The insurance company has to accept or deny a claim within the first 40 days. Well, that sounds great, but they actually have unlimited extensions as long as they provide you with a monthly update on what they're doing. But they have a duty to be diligent, thorough, fair, and objective in their investigation. Diligent means get started as soon as you can, right? Thorough means look at everything. Fair means it's balanced between what is good for the insurer versus the insured, not placing the insurer above the insured. And objective, right? We're looking at these facts objectively, not subjective under the particular subjectivities. We want to make sure that the investigation is designed objectively. No unreasonably low offers. It looks like I have G on here twice, but um, G is a good thing to set forth factors of unreasonableness. We're going to get a little bit later into unreasonableness as in terms of bad faith, but the regulations were established for the insurance commissioner to be able to take actions against insurers. And so they're written a little bit like that, but they're rules that the insurers have to follow, and they're enforceable by policyholders as part of a breach of contract bad faith action. There's no independent cause of action allowed under them, but it's relevant. So then, like I said a second ago, when we talk about bad faith, we'll talk about that means unreasonable behavior. And so subsection G here's got some factors for unreasonableness that are worth taking a look at. Again, 2695.7 applies to more than just first party property. So I've highlighted some that really stand out here. Did the insurance company consider the claimant's evidence? And that's important these days because insurance companies will a lot of the time just ignore what you submit, right? You hire an engineer, they're going to probably ignore it. You hire an estimator, they're probably going to ignore it. They'll hire their own engineer and just listen to that engineer. They'll do their own estimate and only follow their own, at least until you enforce rights. And so they need to consider the claimant's evidence, not just their own. Consideration of legal authority, that's very important. For example, if a case is denied based on it being the claim was reported late, right? And the insurer did not consider the legal authority that they have to prove prejudice to deny a claim for late notice. Well, how about another scenario where it's a little more gray, right? But there is an answer in the legal authority. Well, did the insurance company make some efforts to get a legal review, or did they just go ahead and deny? Consideration of the claims adjuster's advice. That certainly comes into play when you have independent adjusters. Independent adjusters are often retained by insurance companies to evaluate, inspect, prepare an estimate. And oftentimes, when you're doing these claims, the independent adjuster will come out and say, I don't have any authority. I have to do what the insurance company says. I have to follow their guidelines. I'm just the eyes on the ground. Well, no, you can't do that, okay? If that independent adjuster goes out and forms opinions, the insurance company has to consider them. It can't just say, nope, I'm just going to ignore that because we have our own protocol. Then there's some procedures in there for valuing property damage, and we have this catch-all, right? Anything else? Basically meaning anything can be considered as part of a reasonableness investigation. But certainly these factors let you cite to some authority. Let's go to the next slide. All right, so now that we've hit the basics in 2695.7, you'll flip over to 2695.9. These are additional standards that apply to first party property insurance claims. And excuse me, those standards are going to be pretty detailed, and I'm not going to go into them all today in extreme detail, but here's a few I want to point out. Insurance company has to pay for things like matching. If part of the roof is destroyed, but you can't find the same colored shingle anymore, then you have to replace the whole roof so it matches. If the insurance company has a vet that wants to recommend a vendor to you, then they have to tell you that they will guarantee the workmanship of that vendor and that you have the right to choose your own, right? If the insurance company gives an estimate and you get a repair person's estimate, it's higher than theirs. There are certain steps they have to take in response to that. There are some specific regulations about depreciation, which I'll touch on a little more when we get into valuation. This slide also shows some of the other important parts of the 2695 series, which makes up the Fair Claims Settlement Practices Act. So, point three is going to talk about how the insurance company has to document things. And they have to document enough so if the insurance commissioner got their file and was reviewing it, they could recreate the entire claim. So it's important to remember, even though you might not get it until litigation, there should be a claims diary outlining every single thing that happened, theoretically. Point four, we'll talk about what the insurance company has to do in terms of explaining policy benefits and provisions to insureds after a claim. Point five has deadlines for responding to communications, right? Point six talks about what the insurance company and their adjusters have to know, which includes these regulations. And point seven, point nine, we already talked about. So let's keep going on to the next slide. So I want to hone in a little bit on the duty to investigate, right? Because investigating whether a claim is covered, how much it's going to take to repair, how long it's going to take to repair. That is a very large part of first party claims. And once a claim is considered covered, the insurance company has that duty to investigate. Well, no, let me rephrase that. Before it's covered, right? When the claim is made, they have the duty to investigate. And so, what do they have the duty to investigate? Well, the case law, Egan cited here, is probably our preeminent case on insurance bad faith. It's a private disability policy case. It is not a property case, but it is cited more than any other for bad faith. And the duty to investigate, again, it's a regulatory duty, but it's a common law duty as part of bad faith. So, what does it mean, and why do we do it? We do it because it's essential to protect the insured. The insurance company has the money, the power, the wherewithal, the experience. An insured probably has never read their policy, doesn't even really know how it works. And so the insurance company has to help them. They have to, in good faith, thoroughly investigate everything. Now, this quote is about not denying a claim before thoroughly investigating it. But, it really means turn over every reasonable stone. If you know there's something out there that might bear on whether the claim is covered or the value of the loss, the insurance company has a duty to look at it. Can't just bury their head in the sand. Let's go on to the next slide. And another critical point here. Well, when the insurance company fails to properly investigate a claim, it might very well be breaching the duty of good faith and fair dealing. So let's go on because we'll get into bad faith a little bit more detail, but every claim has that key. So burden of proof, I mentioned this a little bit before. So an insured does have burdens of proof. The insured is responsible for showing that the occurrence is within the basic scope of coverage. So, although the insurance company has that duty to investigate, ultimately, when it comes to showing the loss is covered under the coverage provisions, that falls on the insured. So, we were talking about this a little bit earlier. We were talking about well, if it's an all risk policy, there's not much of a burden, right? You just show that the home or the building is damaged, and that's enough. The insurance company then gets to the exclusion. If it's a named peril policy, then you have to show the specific cause. If it only covers fire, water, and lightning, it's the duty of the insured to prove that. Now, and other things, right? Every policy is probably going to say in its covering provisions things like it has to be direct physical loss. Well, that means it's within the scope of proving coverage. And so that's the insured's burden. So we're seeing a lot of smoke damage claims, for example, out of the Palisades and Eaton fires. And there is case law and disputes ongoing about whether and to what extent smoke damage constitutes direct physical loss. So technically, then, that's an insured burden. Next slide, please. As we mentioned, it's the insurer's burden to prove an exclusion, burden of proof on exclusions. It's the insurer's burden. And again, this is very important and really plays into bad faith and the duty to investigate. So, for example, just a few weeks ago, California published an appellate opinion from earlier this year called Nargizian versus State Farm. And that was a really important case because insurance companies have been cutting down their coverages for water losses, and they've been increasing exclusions that are vague, very broad. And some carriers, State Farm in particular, have been denying many claims for those exclusions without investigating. And a big one is slow leaks, right? Or continuous and repeated leakage or seepage or leakage, we call them. And insurance companies like State Farm started thinking, oh, well, if a pipe burst and no one smashed it with a car or a hammer or whatever, maybe it was probably leaking before. So Nargizian was a case like that, and the insurance and State Farm had the duty to prove that slow leak exclusion applied, but they didn't have evidence showing that it was leaking slowly before it burst. They had some circumstantial evidence, but no actual evidence. And like I said, this has become a big problem where insurance companies are denying water claims without investigating in enough detail. And Nargizian held that, hey, the insurer bears the burden. They have the duty to investigate that thoroughly, and they have to prove it. If they can't prove it, then it's covered, right? If there's only circumstantial evidence of a slow leak, but there's also circumstantial evidence that it was not a slow leak, if the insurer can't prove it conclusively, then the exclusion is not going to get applied. Well, let's go on to the next slide. Again, so we're hitting nuts and bolts here, and the efficient proximate cause doctrine is very much an important one because a lot of losses are they occur from multiple causes acting concurrently. And when one is covered and one is excluded, you have a problem because the policies typically say that means it's all excluded. And in some states, that's legally enforceable. But in California, we have Sabella, and we have a few other cases on it, and we have an insurance code section on what we call concurrent causation. And it's the efficient proximate cause doctrine. Really, it's what is the most important cause of the loss? So, for example, this doctrine arose out of landslide losses that occurred post-wildfire. The fire burns all of the structures and it burns all of the trees and their roots around a particular building, destabilizes the soil. And then, let's say, a few months, 6 months later, a year later, there's a landslide and a home is destroyed. Well, earth movement landslide almost always excluded, but what's the most important cause of that loss? Well, in the case on that, it was fire, and fire's covered. So even though landslide was the most recent cause of the loss, the most important cause was fire. So when this happens, there's wear, there's tear, there's also water damage, there's also fire damage. You have to look for the most important cause. All right, let's go on to the next slide. Loss valuation. Again, we talked about this. The insurance policy is going to have its own broad section on this, but here it is broadly. It's replacement cost. Um, Replacement cost is defined in California Insurance Code Section 2051. Who cares what the policy says, right? The statute defines it. And that says, it's the amount necessary, reasonably necessary to restore the property to pre-loss condition. The statute says at the time of the loss. Or no, excuse me. It doesn't. It says when you replace. But actual cash value is another method. And that's where I'm going to hit time of loss. So actual cash value is what you get paid first after a loss. Unless it's a really unique policy, that's all you get paid first. You get paid the replacement cost later if and when you do replace or repair. So what is actual cash value? Well, that's also in section 2051. And that is its replacement cost minus depreciation. Depreciation in the insurance sense, which is a reasonable deduction based on the age and the condition, and only the age and the condition of the property at the time of the loss. And it's a formula that's loosely trying to get you to the actual fair market value of the particular property, right? Because the house that burned to the ground wasn't a brand new product. It was, let's say 50 years old. So you can depreciate certain components of that home based on their age and their condition. Depreciation itself is also defined in 2051 and in 2695.9. It only applies to certain building components. It doesn't apply to things that don't normally wear out. Like you don't normally replace your wall framing, but you do normally repaint through a structure's useful life. But again, without getting too much detail, because this is an overview, you take the estimated cost to rebuild it or repair it, and you subtract that depreciation based on age and condition, you get the actual cash value. That is the essential valuation formula for personal property, for real property. And appraisal, we went over that in detail. Appraisal, again, is if you don't want to do a lawsuit, you can do appraisal over valuation issues. And there are a lot more ins and outs to valuation, but we won't get into that here. Let's go to the next slide. So conditions. Oh, it looks like I'm not seeing the next slide up. I don't know if it's loading or what. Should be slide 18.
It looks like
What?
there's some technical issues. We'll go ahead and resolve this really quickly.
No problem. And, we talked about a lot of conditions before. One thing I'll mention here, and then we'll go on to the slide 19, is, we mentioned that cooperation condition, which can include, exhibiting the property. But then there is a duty to mitigate, which is also in the policy provisions and applies at law. And it's important, those two conditions are important to think about how to balance them. Let's say there's water damage and water turns into mold really fast. It has to be fixed quickly. So a duty to mitigate might say fix it right away before it gets worse. But the cooperation duty is to preserve the property so at least the insurance company can see it. So another fun little interaction there. So my next slides, which we can't see, maybe we will. Oh, good. Okay, let's go to the next slide beyond this one. Slide 19. Okay, so I want to talk about bad faith a little bit. Bad faith occurs when an insurance company unreasonably withholds payment of the claim. Now, here it says unreasonably and in bad faith, but really bad faith means unreasonable conduct. The only real nuance there is it's a little bit more than negligence. It's not standard negligence, but it's a little bit more. How much more? Not much. But importantly, it's a tort. And we're talking about a contract. Now we have a tort. All right, let's go to the next slide. So why do we have a tort when we're talking about contracts? Well, the bargain for peace of mind, which is really what you're buying with an insurance policy, it's because you're going to be paid when you need it. And that and the other reasons I mentioned before, the one-sidedness. Um, well, let's go to the next slide and I'll finish my sentence here. That insured relationship gives rise to these special and heightened duties. And they're implied duties, they're not set forth in the contract. So let's go to the next slide. And so, why do we really have these? Well, without hanging the possibility of tort damages over the insurer's head, they might not choose to deal in good faith. They could gamble, and they still do gamble a lot of the time. Insurance companies are okay dragging a claim out for a long time to, fully investigate it because, the insured maybe goes away, right? Maybe does cheap, crappy repairs. There's a lot of examples. I'm not going to go over them because this isn't a bad faith only focus today, but it's really there to make sure that the policyholder gets the benefit of the agreement. Now, how do you prove bad faith? Let's go to the next slide. Again, it's reasonableness, but are there any red lines? I don't know. Maybe. People ask me this all the time. It's a totality of the circumstances. And sure, uh, enough questionably bad behavior might lead to bad faith finding, or a couple very clear violations of well-established law might. Just not sure exactly what is. But certainly we can do what we lawyers do best, or one of the things we do best, and draw analogies to case law and argue about industry standard and use regulations and statutes as guideposts. So when someone asks you if is this bad faith, well, I don't know. Here's all the arguments I can make, and is it compelling? Let's see. And then let's go to the next slide. One important thing to keep out is bad faith is objective, meaning that the insurance company doesn't have to intend to harm. They don't have to choose to be bad, right? It's unreasonable conduct. And we have something that comes into play when they choose to be bad, and those are punitive damages. And those are available in tort cases, not contract cases, but tort cases. And that's what we have. We have a tort case. And punitive damages are governed by the Civil Code section. There's some ins and outs specific we can talk about. Not going to really do that today. But again, real important. You don't need to look for the adjuster, wanting to back at the insured for reporting them to management or whatever. Certainly it helps, but you don't need to. So let's hit the next slide. All right, just to show some damages, KC 2350, that is our jury and standardized jury instruction here. And so it's kind of nice, right? The damages must include an award for all harm that was caused by the defendant, even if it was not anticipated, aka not foreseeable. That is a claim, a statement that you can get consequential damages like other torts, but here, even if they're not foreseeable, that's pretty cool. If you're the plaintiff, not if you're the insurer. So some examples, it's kind of nice here again how Casey lays it out. One, mental suffering, anxiety, humiliation, emotional distress. Number two, attorney's fees. Number three, insert other item, right? That number three really gives you wide open. But hit number one and two real quick. So this is one of those torts where emotional distress can be awarded without having to follow those normal rules for negligence cases. Doesn't have to be within, the zone of danger or whatever the particular, case law is for whatever case you're thinking of that's other than a bad faith case. But for bad faith, it's mostly tied to financial distress from the money that you're owed being withheld. And it can just grow from there. But you don't really have to prove it with doctors or therapy notes for an emotional distress award to be upheld. So it's a little bit different than, what you may see in personal injury type cases. Attorney's fees. So we have this case called Brandt, Brandt, and this case called Cassim, Cassim. Brandt says that if there's an unreasonable claim denial, then the cost of attorney's fees to recover the benefits are recoverable. That's great. You have to prove bad faith, not just breach of contract. Cassim does this really weird thing we don't like. It says, well, you only get the attorney's fees to prove the claim was covered, but not to prove there was bad faith, which is kind of weird because normally you would think it's the same. But we have to be careful, and you have to be careful when attributing, an action you're doing in your timekeeping notes, whether, is it exclusively to bad faith or not. Keep that in mind because when those get reviewed for a fee award, the judge under CASM cannot uh, award attorney's fees solely for pursuing bad faith. I guess if you were trying to prove it's a company-wide practice and you were talking about their policies and procedures in general, perhaps that might not be recoverable, the time attorney spent doing that. Well, that's all I have in terms of slides, but we have a few minutes left. I'm not sure if we have any questions. Looks like we may. Let me see. I'm not sure. Okay, we have a couple questions here, and you know what? I'll just go ahead and read those. So, number one, can an insurance company cancel a policy in the middle of a policy period? That's a good question. So, yes, they can. There are specific insurance code regulations or not insurance code statutes that specifically say how you can do that. And there are enumerated basis for cancellation. And some of them, most of them, uh, the cancellation has to be within the first maybe 90 days of the policy. And then after that, it gets more limited. And there are different rules for commercial policies than homeowners policies, as well as for surplus lines policies, which are non-admitted insurers. That's a whole different scenario. But that's cancellation. That's when a policy in force for that 1 year period just canceled. It was in force until this date. Now it's done, right? There's also something called rescission, which what policy just doesn't exist anymore. That's completely different. Non-renewal is next year, we're not going to reissue the policy. We're not going to insure you anymore. So different, but cancellation for middle of a policy term, got to follow the statute, not just for the reasons for cancellation, but also for notice. So, for example, a few years ago, we had a really big case, the cancellation overturned because they didn't specify the reason for cancellation with enough clarity in the notice. I have another question. Does 2695.7 also apply to third-party statutory or tort claims? So in terms of statutory claims, I'm not 100% sure what that is meant to apply to or refer to here because statutory there are no statutory uh, causes of action, at least for the breach of a contract in bad faith. There's UCL claims you can bring, but in general, we don't have those. In terms of does it apply to third-party claims? I'm not a third-party expert. I believe the answer is yes, but you have to keep in mind that these are regulations that typically govern the relationship between the insured and the insurer. So if you're representing a third party that's suing the insured and you don't like what the insured's insurer is doing, these regulations won't necessarily help you. I'm not sure, Judith, the court, do I have a download of court materials? So I don't have anything on hand, but you can email me. Honestly, the cases are very good. We have jury instructions for sort of the core breach of contract and bad faith claims, and they do a pretty good job of citing to important cases. The Rudder Guide is also is also fantastic for property insurance, and I think for most insurance litigation, it's very good. And then again, Merlin Law Group, the property coverage blog. You can find it on our website. It is genuinely, considered the best blog for this industry. We do an article daily, and everything can be searched online. So that is another great resource. Also, I'm on the board of United Policyholders, and I'd be the executive director would want me, of course, to remind everyone United Policyholders is also, it's a fantastic resource. And it's really designed not for us lawyers, but it's designed for policyholders. And it's got a lot of resources for when you have a claim going on, you need assistance. Great stuff for attorneys trying to figure this out too. And it's a great organization to be a part of, find ways to volunteer, etc. But this is an extremely complicated area of law, very complex, lots of nuance, and it's very difficult just to get an understanding of how the first party industry works. And they're very expensive cases. A lot of experts are involved. So absolutely, think carefully if it's a case, the type of case you want to try taking on for the first time in your practice. But again, my contact info is here and I'm available to answer more questions. And thanks everyone for attending. I hope this was valuable.
This concludes today's presentation. Thank you so much, Daniel, for an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everybody.